Good morning. My name is James Quinn and I'm a solicitor in the dispute resolution team at Boyes Turner, and I'm joined this morning by my colleague Rachel Brown. In the first part of this morning's webinar, Rachel will be looking at issues to be in English court proceedings against your counterparty, where your contract has an English jurisdiction provision and where your counterparty is domiciled in the EU or beyond. She will also look at issues arising when you come to enforce your English court judgment against those parties. In the second part of the webinar, I will then look at the equivalent steps in arbitration where your contract contains an arbitration clause. I will discuss the process for commencing arbitration under some of the commonly used arbitral institutional rules and under the Arbitration Act 1996. I will also look at the steps available to you to enforce the arbitration award against that overseas party and some of the considerations arising. We're considering these matters where your contract is already in place and the dispute subsequently arises. However, the matters which we'll run through today may also assist in determining whether it would be advantageous for your future contracts to provide for disputes to be determined by the English courts or by arbitration. We'll talk for about 30 minutes, and so we'll use the full time allotted. So if you have any questions, please do feel free to email them in afterwards. And so I'll hand over to Rachel.
Thank you, James. Looking first at jurisdiction, in the EU regulations, often referred to as the Brussels regulations, it provides that parties should be sued in the courts of the EU member state where they are domiciled, with the exception being that where the parties had agreed that the courts of a particular EU member state had exclusive jurisdiction, then only that court will have jurisdiction. If proceedings are brought in courts in another EU member state, then those other courts should stay proceedings pending determination of jurisdiction by the chosen court. The position now that the UK has left the EU is that unless the Hague Convention applies, which I will deal with in more detail later, it will be for the domestic laws of each EU member state to determine whether or not to give effect to a clause giving jurisdiction to a UK court, or for UK domestic law to determine whether or not a clause giving jurisdiction to an EU court would be effective. So when the defendant is domiciled outside of England and Wales, we need to check whether the English courts have jurisdiction to hear the matter before commencing proceedings. Determining jurisdiction is done by reviewing the terms of the contract in place between the parties, including any terms and conditions, to establish what is provided for in terms of jurisdiction. If there is an exclusive jurisdiction clause, providing that the English court shall have jurisdiction, then you should be entitled to commence proceedings in the English courts. The position is more difficult where the contract contains a non-exclusive jurisdiction clause or is silent as to jurisdiction, particularly now that the UK has left the EU. A non-exclusive jurisdiction clause is one which, for example, provides that the English courts have jurisdiction to hear a dispute, but without prejudice to the rights of one or other of the parties referring to the dispute to another court of another jurisdiction. Despite Brexit, jurisdiction clauses which provide for the English courts to have exclusive jurisdiction is still of importance when drafting contracts. For example, the English courts and its lawyers have extended experience in dealing with complex and large international disputes. There's also substantial case law and precedent to give parties greater certainty on outcomes. The English courts have a wide variety of interim measures, and the use of English language is also advantageous across international parties. When looking at the Brussels regulations, they provide clear rules on governing laws and jurisdiction, together with service of proceedings and recognition of judgments. Pre-Brexit, permission would not have been required from the court if the debtor was to be served within the EU, and there was a jurisdiction clause in the contract. Both pre and post-Brexit, a certified translation of the court documents to be served and an amended response pack providing for the number of days for a response is required. Service within the EU was also fairly straightforward up until the end of December 2020, as the EU service regulations provided accepted methods of service for each country within the EU, and each country also had designated central authorities for the sending and receiving of proceedings to be served. As a result of these regulations, the process was much streamlined compared to the position we find ourselves now in. It was also straightforward to enforce a judgment obtained in the English courts in the EU, because under EU regulations, it was automatically recognised in other EU member states. And so there was no requirement to apply to the courts in the debtor's member state for the judgment to be registered before you could take enforcement action. If proceedings were commenced before the 31st of December 2020, then the EU regulations will still apply to the case in terms of both service of proceedings and recognition of judgments. And so such a judgment, you can rely on the Brussels regulations if the defendant is in the EU, or the Lugano Convention if the defendant is domiciled in Iceland, Norway or Switzerland. It's under Articles 36 and 39 of the Brussels regulation that judgment of EU member states is automatically recognised and enforceable in another EU member state without the need to take court action in that member state. Having left the EU regulations in relation to service, recognition and enforcement no longer apply. And the trade and cooperation agreement between the UK and the EU does not provide any replacement rules for proceedings issued in the English courts. As a result of leaving the EU, the UK also lost its membership to the Lugano Convention, which is an international treaty between the EU member states and Switzerland, Norway and Iceland. The Lugano Convention provides a similar framework for service of proceedings as the EU's Brussels regulation, in addition to dealing with jurisdiction and recognition and enforcement of judgments. On the 8th of April 2020, the UK submitted an application to join the Lugano Convention in its own right. However, it was not as simple as the UK simply rejoining the Lugano Convention, as we can only join if the other contracting parties unanimously agree. Unsurprisingly, the European Commission recommended that the EU member states should deny the UK's accession, and on the 28th of June 2021, the European Commission formally blocked the UK's admission to the Lugano Convention. Its reasoning was that Lugano characterises an essential feature of common area of justice and is based on a high level of mutual trust among the contracting parties. As the UK chose to leave the EU, it is alleged that there can no longer be that high level of trust. We're therefore currently left in a position where we need to look at what treaties are in place between the UK and other countries which provide for service. And the main convention relied upon for this purpose is the Hague Convention on Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, known as the Hague Convention. The Hague Convention provides a set procedure for service of court documents on parties located in one of its 79 contracting countries. The Hague Convention has been in force in the UK since the 1st of October 2015 as a member of the EU, and then following Brexit, the UK joined the Hague Convention in its own right on the 1st of January 2021. Whilst it is helpful that the UK has successfully joined the Hague Convention, there are some key differences to the Lugano Convention and the Brussels regulations. The first and most important of which is that the Hague Convention does not apply to non-exclusive jurisdiction clauses. And so now it is even more important to consider the jurisdiction clauses within your contracts. Another difference is that a judgment given by an English court pursuant to the Hague Convention will be recognised and enforced in the EU in accordance with the provisions of the Convention, but it does not provide for reciprocal recognition and enforcement of interim measures, such as measures of protection, such as freezing orders and injunctions. There are also other exemptions, such as it does not apply to insolvency proceedings. There is potential uncertainty where exclusive jurisdiction clause being relied upon between the parties was agreed after the 1st of October 2015, when the Hague Convention came into force, but before the 1st of January 2021, when the UK left the EU. The reason for the uncertainty is that the EU has raised some arguments that as the UK only joined the Hague Convention in its own right on the 1st of January 2021, it cannot rely on the protection provided by the Convention by relying on its previous membership of the EU. If you do have an exclusive jurisdiction clause and the country in which the defendant is domiciled is a member of the Hague Convention, then you will not be required to make an application to the court for permission to serve out of the jurisdiction. It will simply be a case of completing the form to accompany the claim form indicating that there is an exclusive jurisdiction clause in place. Turning to commencing proceedings when that Hague Convention doesn't apply, where there is no jurisdiction clause, exclusive or otherwise, permission of the courts to serve out of the jurisdiction will be required. The application for permission is made at the same time as submitting the claim form to the court, and the application will be supported by a witness statement requesting permission under common law to serve the claim form on the debtor outside of the jurisdiction. To obtain permission to serve out of the jurisdiction, it must be shown that 1, there is a good arguable case that each claim falls within at least one of the jurisdictional gateways at paragraph 3.1 of Practice Direction 6B of the Civil Procedure Rules, which serve to establish a connection between the claim and the jurisdiction of England and Wales. And 2, there's a serious issue to be tried or a reasonable prospect of succeeding on the merits of the underlying claim. And 3, that England and Wales is clearly or distinctly the appropriate forum, and the court should exercise its discretion to give permission to serve proceedings out of the jurisdiction. In relation to service of proceedings, once proceedings have been issued and permission has been granted, the court documents need to be translated into the official language of the country where the debtor is domiciled. It doesn't matter whether the defendant speaks English, the documents still need to be translated into the language of the official language of the country where the debtor is being served. The translation has to be carried out by a qualified translator who can provide a certificate setting out their qualifications and certifying that the translation is correct. The main method of service under the Hague Convention is that requests for service coming from one contracting state are transmitted to the central authority of the state where service is to be effected. There are other methods of service available, but a number of the contracting states have objected to service by other methods. And so if serving on a Hague Convention state, we would recommend arranging service by providing the documents to be served to the Foreign Process Section at the Royal Courts of Justice, who have everything they need for service under the jurisdiction. Will send the papers to the central authority of the country where the defendant is to be served, and they will then arrange service on the defendant. Where the Hague Convention does not apply, it is particularly important to look at what the rules of service are in the country where the defendant is domiciled, to ensure that proceedings can be served in accordance with both the English law and the law of that country. It's worth bearing in mind that it can take a few months for service to take place and for you to receive evidence of service. And so it's important to ensure that there is still sufficient time to run before the period for service expires, which is normally 6 months. And if that time period is getting close to expiry and the claim form has not yet been served, or you've not yet heard back with evidence that it has been served, you will need to make an application to the court for an extension of time for service of the claim before that original time period expires. Turning to enforcement of judgments. Once a judgment has been obtained, but before it can be enforced, it will need to be registered or recognised in the courts of the country where the defendant is domiciled. It's worth having good working relationships with lawyers in different countries so that you can check on the rules for recognition of judgment and how best to ensure that your judgment is going to be recognised before proceedings are issued, or at least at an early stage. This is important because, by way of example, certain countries won't accept a judgment which has been obtained in default or without a hearing having taken place. If your judgment is one which the Hague Convention applies, then the rules for both recognition of the judgment and enforcement of the convention will apply. And so the court is bound by the findings of the court where the judgment was entered. And so they will not review the merits of the case unless there are issues with recognition and enforcement. For example, the enforcement of punitive or exemplary damages may be refused. The Hague Convention, therefore, has restrictions which the EU regulations and the Lugano Convention does not. Most importantly, that it only applies to cases where there is an exclusive jurisdiction. And it also excludes consumer and tortious claims. Where judgment is not one obtained under the Hague Convention, i.e. where there's no exclusive jurisdiction clause, or where the country the defendant is domiciled is not a member of the Hague Convention, the recognition and enforcement of the judgment will either be pursuant to any other treaty between the relevant countries or under the national law of the country where the defendant is domiciled. There are various other conventions, statutes and treaties which apply to the enforcement of foreign judgments in the UK. For example, the UK has a statutory regime under the Administration of Justice Act 1920, the recognition and enforcement of judgments applying to most Commonwealth countries and British overseas territories, and also to Cyprus and Malta. Another relevant statute is the Foreign Judgments Reciprocal Act, Enforcement Act 1933, which applies to judgments from courts in Australia, Canada, Guernsey, India, Isle of Man, Israel, Jersey, and Pakistan. The Act also applies to judgments from some European countries, Austria, Belgium, France, Germany, Italy, the Netherlands, and Norway, that have entered into bilateral treaties on enforcement of judgments within the United Kingdom before the UK acceded to the European Union, or in the case of Norway, they have entered into and amended and updated bilateral treaties with the United Kingdom post-Brexit. If the judgment is one which falls within the Hague Convention, Administration of Justice Act, or the Foreign Judgments Reciprocal Enforcement Act, then a creditor can apply for their judgment to be registered under the rules set out in Part 74 of the Civil Procedure Rules. The process involves applying to the High Court Master with support of written evidence. The application should include a verified or certified copy of the judgment and a certified translation if necessary. The judgment debtor then has an opportunity to oppose registration on certain limited grounds. Assuming the judgment debtor does not successfully oppose registration, then the judgment creditor can take steps to enforce the judgment. For judgments that fall within the common law rules, the judgment creditor must commence a claim in the English courts under Part 7 of the Civil Procedure Rules to obtain an English judgment. It will usually be possible to apply for summary judgment under Part 24 of the CPR. An application for summary judgment must be supported by written evidence. Once the judgment creditor has obtained an English judgment in respect of a foreign judgment, that English judgment can then become enforceable within England. I'll now pass you back to James.
Thanks, Rachel. Turning now to the commencement of arbitration proceedings, the point I'd like to make here is that we do not have the same sort of uncertainties that Rachel has just taken us through in terms of which rules will apply in relation to the commencement of arbitration, whether this is against counterparties domiciled in the EU or outside the EU. In each case, it will be a question of following the rules which have been chosen to apply to the arbitration when beginning the arbitration proceedings. However, the steps to follow under the applicable arbitration rules for commencing arbitration are often not without their complexities, and it is important to get these steps right in order to avoid presenting your counterparty with a potential defence to the subsequent recognition and enforcement of any arbitration award. In this next section of our presentation today, I'll look at these steps that are to be taken to commence arbitration under two sets of arbitral rules which are commonly chosen by the parties to international contracts, as well as the process under the English Arbitration Act, which international parties sometimes choose to apply to disputes arising under their agreements. The rules of the London Court of International Arbitration, or LCIA, are commonly chosen by parties to international contracts. Article 1.1 of the rules provides that to commence arbitration under the rules, the claiming party must deliver a written request for arbitration to the registrar of the LCIA which is to include, amongst other things, the full name and all contact details, including email address, postal address, and telephone number of the respondent party or parties. As we've set out on the slide, Article 1.1 goes on to prescribe what else must be set out in the request for arbitration, including details of the arbitration agreement, brief details of the claim and any supporting documents, details of any agreed procedural matters, and confirmation of payment of the registration fee. Article 1.17 provides that the claimant must give confirmation that the copies of the request, including all accompanying documents, have been or are being delivered to all other parties to the arbitration, in accordance with Article 4, by one or more of the means to be identified specifically in the confirmation as supported by proof of actual delivery. It is, of course, important to ensure that the names of the parties are spelled correctly and the address and full contact details for the respondent party are all up to date. As we've just seen under Article 1.17, it is the claiming party initiating the arbitration which is responsible for delivering a copy of the request for arbitration to the respondent party. Article 4 deals with how communications are to be made, and it provides that delivery by email or other electronic means of communication shall be as agreed or designated by a party. Under Article 4.1, the request for arbitration is to be delivered to the registrar of the LCAA by email or other electronic means. Article 4.2 provides that any written communication in relation to the arbitration allows a party to apply to the registrar or subsequently the tribunal for permission to deliver a written communication other than by email or electronically. Your contract might provide, for example, that any communication commencing arbitration is to be delivered in a prescribed manner, such as by international courier. In this case, you should consider seeking the permission of the registrar to deliver the request in the manner as agreed in the contract. In addition, you may want to take advice from lawyers in the country or countries in which you will be looking to enforce any award, whether delivering the request for arbitration by email or electronically would be acceptable in that country, or whether this might give rise to any uncertainties with subsequent enforcement action. It may be, for instance, that the recommendation is to deliver a copy both in a hard copy by courier and electronically by email. It may be that you have good relations with your counterparty, in which case it may be possible to agree and or clarify these matters before starting arbitration. However, this might not always be the case, and indeed your counterparty might be and remain entirely silent during the commencement process or even the whole of the arbitration, in which case to get this process right. Article 1.4 of the rules provides that the arbitration shall be treated as having commenced on the date on which the request is received electronically by the registrar, as long as the LCIA has also received the registration fee. This is important for the purpose of stopping the limitation clock. However, as I've just mentioned, it is also important to keep in mind the importance of delivering the notice properly in accordance with the rules and in accordance with your contract, and also taking into account local laws in the place or places in which you may ultimately be looking to enforce any award. The ICC rules on arbitration are also very commonly used in commercial contracts between international parties. As with the LCIA rules, the ICC rules require a claiming party wishing to commence arbitration to submit a request for arbitration to the Secretariat of the ICC. The request must contain information set out in Article 4.3 of the rules, and this includes the full name, description, address, and other details of each of the parties to the arbitration and the claimant's representative, as well as the arbitration agreement, the claim, and any supporting documents. And as we see on the slide, unlike the LCIA rules, where the claimant party is responsible for delivering the request for arbitration to the respondent, under Article 4.5, it is the ICC Secretariat which transmits a copy of the request for arbitration and any supporting documents to the respondent. Although it's the ICC which is responsible for sending a copy of the request to the respondent, rather than the claiming party, you should again bear in mind potential enforcement and consider any contractual provisions as to how the request should be communicated under the contract, and to take any local law considerations which might apply so that the delivery of the request by the ICC is in accordance with any contractual requirements and local laws. If the recommendation is that the request should be delivered in a certain way, for example, by international courier, then a request can be made to the ICC, but it should deliver a copy of the request to the respondent by international courier. Again, as for the LCIA rules, Article 4.2 of the ICC rules provides that the date of commencement of the arbitration is deemed to be the date on which the request has been received by the Secretariat. As I mentioned earlier, whilst the date of commencement is of course important for limitation purposes, just as important is the need for the request to be transmitted to the respondent in such a way that it will not cause an issue with subsequent enforcement. Whilst it's possible to clarify or agree upon these matters with your counterparty prior to beginning arbitration, this isn't always possible, and you will want to ensure that the arbitration is commenced in accordance with the rules and in such a way which will not prejudice any subsequent enforcement. Sometimes parties will agree to what is referred to as ad hoc arbitration, which is not governed by the rules of an arbitral institution, but instead by statutory arbitration rules in place in a particular country. In England, the relevant statute is the Arbitration Act 1996. Set out on the slide are the provisions of section 14 of the Act, which deals with how an arbitration is to be commenced under the Act, and when it is deemed to have been commenced for the purpose of the Limitation Act. This may be provided for in the contract or in the arbitration agreement. However, if it is not, then subsections 1 to 5 prescribe how the arbitration is to be commenced. In each case, it involves the initiating party serving a written notice on the other party or parties, calling upon them either to submit the matter to a pre-agreed arbitrator, subsection 3, or to appoint an arbitrator where the arbitrator or arbitrators are to be appointed by the parties, subsection 4, or to a third party where the parties have agreed that the appointment is to be made by such a third party. So what does the Act say about serving a notice under section 14? As we see on the slide, section 76.3 provides that a notice may be served on a person by any effective means. Pursuant to case law, effective means includes email, although it is important to use correct email addresses, of course. Otherwise, subsection 4 goes on to deal with a situation where a notice is sent by prepaid post and requires this to be sent to the addressee's last known principal residence or place of business or registered or principal office. The LTIA rules set out its own code for how the arbitral tribunal is to be appointed, including in a default situation where one party fails to nominate if the arbitration agreement provides for this. The LTIA court is responsible for appointing the tribunal, and the registrar will notify the parties of the arbitrator or arbitrators who have been appointed. The parties may choose their arbitrator or arbitrators, although this choice will be confirmed by the ICC. Further, if the arbitration agreement requires the ICC to appoint an arbitrator, or if a default situation arises and the ICC has to appoint an arbitrator, the ICC will make the appointment and will notify the parties of the appointment. The parties will commonly agree that the tribunal will consist of 3 persons, or alternatively, a sole arbitrator. Section 15 of the Arbitration Act 1996 provides that where the parties have not chosen the number of arbitrators, then there shall be a sole arbitrator. The Arbitration Act provides for a default process. The agreement does not specify what happens where there is a failure in the process of appointing the tribunal. And we've put on the slide the wording of section 18 of the Act, which deals with this. This provides for an application to be made to the court in order for the appointment to be made by the court. Most commonly, this will be invoked where the arbitration agreement provides for the appointment of a sole arbitrator, but where the parties cannot agree on who is to be appointed. In this situation, it will be necessary to issue an arbitration claim form with the English court and serve the claim form on your counterparty. In this one instance, we are then in the territory which Rachel has described for the service of English court proceedings on parties domiciled in the EU or elsewhere. And as we've talked about before, in a situation where there is good cooperation between the parties, your counterparty's lawyers may confirm instructions to accept service of such a claim form. However, if they do not, or if the counterparty is not responding, it will be necessary to go through the service steps which Rachel has described. We heard from Rachel on potential complexities of enforcing an English court judgment overseas, particularly against parties domiciled in the EU. In contrast, the 1958 UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards aimed to create a set of rules which will be adopted widely for a consistent approach to the recognition and enforcement of arbitration awards across different countries. There are now 167 signatories worldwide, although it's important to note that some countries have exceeded the convention, but only as regards awards made by certain other specified countries. It's always necessary to check whether an award made in the seat of arbitration will be recognised and enforced in the country where you anticipate enforcement action is likely to be necessary. The UK is a signatory to the convention, and its principles are reflected in the sections of the Arbitration Act 1996 dealing with the recognition and enforcement of arbitral awards. Although the provisions of the convention have been reflected in the domestic law of the signatory countries, there are sometimes variations in some of the precise rules, and it's always sensible to check with lawyers in the country or countries where you anticipate having to enforce an award, whether there might be any special rules to take account of in relation to recognition and enforcement, so that you are aware of these from the outset. Looking straight away then at the provisions of the convention, Article 1 provides that the convention shall apply to international disputes, i.e. for awards made in a country other than the country where the recognition and enforcement of the award is sought, or which is otherwise not considered as domestic in that country. In other words, it won't apply, for example, to awards made between 2 parties who are both domiciled in the UK. As I mentioned a moment ago, some countries have acceded to the convention, but only as regards awards made by certain other specified countries. It's always necessary to check whether an award made in the seat of arbitration will be recognised and enforced in the country where you anticipate enforcement action is likely. Under Article 2 of the Convention, there will need to be a written arbitration agreement between the parties and signed by the parties or contained in the exchange of letters or telegrams. Telegrams are seldom used these days and more commonly used forms of communication generally accepted by the courts, including electronic communications. Article 4 of the Convention sets out the requirements for the recognition of the award. And as we see, the requirements are quite straightforward, and it is necessary to supply a copy of the award and a copy of the original arbitration agreement in translation if necessary. Article 5 of the Convention sets out the basis on which a party can object to the recognition of an arbitration award, and we've set out the terms of Article 5 on the slide. The ground which I want to focus on here is ground B, which provides that the court may not recognise the award where the party against which the award is invoked was not given proper notice of the appointment of the arbitrator or the arbitration proceedings, or was otherwise unable to present its case. As I explained earlier, in the context of the commencement of the arbitration proceedings, whether this is pursuant to institutional rules or by statute, it's important to ensure that the arbitration proceedings are commenced properly in accordance with the applicable rules and taking account of any relevant local laws to ensure that the counterparty is not able to rely on this part of the convention when objecting to subsequent recognition and enforcement of an award. So we've run through the various complexities involved with commencing English court proceedings and enforcing English court judgments against overseas parties, particularly where those parties are domiciled in the EU. We've contrasted this with what could be said to be a clearer, more certain position, at least for the time being, of the equivalent steps in an arbitration context. As ever, the key will be to follow the applicable processes and seek advice from overseas counsel at various points during the process. When considering the dispute resolution provisions of future contracts, which we are negotiating, thought should be given to the issues concerning the commencement of formal legal action and enforcement issues, as to whether this will be through a jurisdiction or arbitration provision, so that you will have the most effective and convenient measures available to you to bring legal action and ultimately enforce your rights against your counterparty. So that concludes our webinar this morning. Thank you very much for joining.